That it would have been allowable.
It would have been allowable.
But just because defense counsel didn't have an expert witness, that's determinative.
I believe so, because I think that it's outside of the common sense of the juror. And I think to assume that the jurors would know crack cocaine use, it's just not similar as alcohol or things like that. You would hope that you would have a jury that probably wasn't that familiar with crack cocaine use, frankly. So in order to get there, I think there has to be more evidence presented or more foundation laid to say, not she's a crackhead, you can't believe her because that's improper impeachment, but that she was using crack cocaine that day and it would affect her memory thusly. And that was not done.
Now, there was another witness that was there at the time, Miss Lee, I think. Is that right?
Carolyn Lee, yes.
Did these same issues come up regarding her and what she happened to be doing there that afternoon?
I don't recall if she was even asked that.
And there was no motion in limine as to her testimony, no order in limine issued as to her testimony?
Correct.
Was there any inquiry made by the defense counsel about whether Ms. Lee was somehow delusional or unable to think on that day because of drugs, alcohol, or other?
No, I don't believe so.
What was the defendant's defense at trial?
That she didn't do it.
Did she testify?
No.
Excuse me.
I don't know if that was on the record. No, I apologize. I was going to say I think that she implied that she had no memory of what had happened. I think that was on the record because of some drug use of her own, that she was in the hospital and couldn't recall or wasn't there. I think that was her defense. In addition, I think it's already been noted that there was some mention of crack cocaine. But the state's point is what I made, that it would have been relevant had there been more foundation, had there been other testimony that could be had. The state's position was the reason it was being used for was not relevant, was improper impeachment.
Was there a written order in limine or just the motion transcript?
I believe it's just the motion transcript.
Because it appears from looking at that transcript that the only thing the judge actually prevented was the mention of crack cocaine, which indeed actually at trial there was evidence entered into the record regarding crack cocaine. So you don't think there was a written order?
I don't believe so. And I have no further comment unless there's other questions. Thank you.
Thank you. Any rebuttal?
Your Honor, just to clarify the court's question about the motion in limine, it was a separate hearing, and then it continued also on the volume 1 of the jury trial, the continuation of the court's ruling. And he specifically says if he can ask if she consumed or used any drugs or medication in the day, during that day, and if she answers yes, then he can go further into it. But if she says that her perceptions or ability to understand questions isn't affected, if she says no, then we're done. That's what he says. If she says no, then we're done. So he can't go further into asking her questions about that.
Or challenging her opinion.
Exactly. And, who's...
Yeah, I was on all sorts of psychotropic drugs. I was on cocaine, drinking lots of alcohol that day. Did it affect you? No, not at all. Well, could I ask Judge? No, you can't ask any more questions.
Exactly.
You got to sit with that. And you haven't quoted, and I forget who the U.S. Supreme Court Justice was, who referred to the cross-examination and the constitutional right to cross-examination as the great engine of our judicial system. I mean, that's how we make sure that there's fairness and proper convictions, is through that battle of defense counsel and witnesses.
Exactly.
The defense counsel preserved by proffer this testimony that, assuming that he wanted to get in this testimony about perception and follow-up, was there a proffer made?
I don't know if there was a specific proffer, except that he does mention her preliminary hearing testimony, which it went definitely more into how she was affected by the drugs, how many times she used it, that she was going to rehab, et cetera, et cetera. And then at trial, she says, I wasn't affected by it. And he even asks her, were you supposed to go to rehab? And she says no. So, I mean, there is a big discrepancy in her testimony. And so he did proffer that in the sense that he was challenging what she said at preliminary hearing, and the judge made its ruling after that, so.
Let's say we set aside the victim's testimony. Was Ms. Lee's testimony sufficient?
During her cross-examination, she said that she was on several medications and that her memory is bad. So, it seems like everyone was having memory problems that day, but.
I think they also got out in the record that it was a neighborhood that was known for illegal drug activity.
Exactly. So I don't know if her testimony was sufficient for conviction either.
Was defense counsel prohibited from asking her those types of questions?
He wasn't specifically prohibited from that, but it doesn't seem like he necessarily did that too thoroughly on cross-examination of that witness, that secondary witness that was there. And I don't know why, but it did come out that her memory was bad.
But there was no order in limine preventing counsel from inquiring of her about her memory or what they were doing that day, smoking.
I believe the motion in limine was directed towards the complaining witness, Ms. Williams. There's no further questions? All right, thank you.
We'd like all of you to stick around if you would. We're going to go take our robes out, and then we'll come off, and then we'll come back in and talk to you a little bit and answer some questions. So we will be in recess. Thank you.
We're not at a trial court level here, we're at a different level of court. And so if one of the judges would talk to the students in the audience about that.
Well, we heard Judge Knutson's answer earlier, so we're going to have Judge Boozer's answer to that question to see if it's the same.
Thank you.
Think of it as a triangle. We've got, at the base of the triangle, you've got the district courts. These are the courts that, Judge Judy, you've got cases where the evidence is being presented, you've got juries, facts are determined, witnesses appear. That's at the district court level. And I think we've got, 180-some district court judges throughout the state of Kansas. Then once you get a verdict there, if you don't like what happens, you then would appeal to the next level of court, which is the intermediate appellate court, which is the Kansas Court of Appeals, which is what we sit on. We have 13 members. We sit in panels of 3, and we have to, in effect, hear any case that a person appeals who loses at the district court level, at the base of that triangle. We have to take the appeal, and we have to issue a ruling. Then once the 3 of us decide the case, if we'll issue a decision, and if the losing party doesn't like that decision, you have an opportunity to appeal to the very tippy top of the triangle, which is the Kansas Supreme Court. Now, there are 7 members of the Kansas Supreme Court. They don't have to hear the appeal. They only grant the appeal if they want to, if they take a look at the case and the briefs and they say, oops, Judge Bruns has messed up again. And so we're going
highly unlikely.
We're going to take a look at it, and it'll be re-argued in front of the Supreme Court in Topeka, typically, and then they'll issue their ruling. For the most part, that is an end to it. Actually, for the most part, because our Kansas Supreme Court only takes 70, 80 cases a year, I believe, our decision at the Court of Appeals level will be final. And we do both criminal cases and civil cases. Our jurisdiction is the state of Kansas. So one day I'm working on a case out of Dodge City. Next case I'm working on something from Leawood. And the cases range from what's the value of a dog. I had a very famous case on what's the value of a 17-year-old Yorkshire Terrier that I had to determine versus very serious crimes, like you heard today, aggravated battery. So, and civil cases, divorces, adoptions, juvenile cases, traffic cases, whatever. So that kind of gives you an idea.
Okay. Maybe you would explain to them, there was a lot of comments being made about a motion in limine, and maybe you could explain just what that is and what resulted from it, just in case it's not clear.
Take that one?
Sure. First, I want to take the opportunity to thank your president and all of you here at the college for your hospitality to us and the way you welcomed us and paid attention to what was going on in court. We appreciate it very much. In regard to a motion in limine, it is simply a pretrial procedure by which one of the parties is trying to keep, even out of the hearing of the jury, information that would be prejudicial and inadmissible at trial. So in the case that you heard this morning, the issue was, is there relevance to permitting the defendant to cross-examine the witness and ask the witness, who is the alleged victim, was she using crack at the time or near the time this incident occurred? So the prosecutor's thinking, I'm just trying to get inside the prosecutor's mind, the prosecutor's thinking this is highly prejudicial and inadmissible. If the jury hears it, damage is done. That's the real key issue. Just hearing it is damage with this kind of inflammatory evidence. Or as one of my law student friends said it in tort class, if it's inflammable. But at any rate, so they're trying to just keep it out of even the hearing of the. So there's a mechanism, a motion in limine, which means it can't be presented at all in front of the jury if the trial court grants the motion in limine. So in this case, that's what happened. The trial court, with some conditions, granted the motion in limine, and it is to keep the prejudicial information from even being heard by the. It's one of those cases, as you know, we talk about all the time, and you guys have used the phrase, once you ring the bell, you can't unring it. Yeah.
The other phrase is, once you throw the skunk in the jury box, they're going to notice whether or not they're told by the judge later not to. I mean, the damage is done.
Okay. Should the attorneys or the audience read anything into the way that you question the lawyers?
Probably depends who's doing the questioning. I think at the Court of Appeals, probably not as likely. The United States Supreme Court has quite the tendency to present argument to one another through their questionings. Justice Scalia is known for that, and often their questions are just as much directed for other panel members as it is to the lawyers. But that can happen on occasion, even at the Court of Appeals.
Well, teachers and students can understand this. It's a little different question, but often we'll ask questions of an attorney, and an attorney doesn't answer the question. And it could be the attorney wasn't listening carefully or chooses not to answer the question. And so those are significant exchanges. But as Judge Brunn said, ordinarily we don't mean to suggest that we're going to decide a case in a particular manner based upon the questions that we ask, but we may play the devil's advocate, and we may ask some tough questions because the litigants deserve for tough questions to be asked. Yeah.
This question would come up, I'm sure. Why is it that there's an attorney up here arguing before you who obviously did not try the case? And so there's apparently holes in her understanding of what happened at the trial. So when you ask the questions, they may not be effectively answered by the attorney arguing the case.
Well, frequently in criminal cases, the attorneys are appointed, and it's just the way the system is set up. The system is set up so that local communities, like in Wyandotte County, the Wyandotte County Bar and the judiciary will set up a legal aid or a public defender who will represent the person at the trial court level. But then the state has set up an appellate defender system. So the Ms. Labastida is an appellate public defender. So that's all she does is hit the books, write briefs, and argue. But there is a disconnect as a result of that, the way the system is set up, that the person who handles the appeal, has not been involved in the trial. Now, they, of course, have access to the transcripts, as do we, so you have a pretty good understanding of what's going on. But there is, in the typical indigent criminal case, a disconnect, which you don't have in a civil case where the civil attorney will represent the person below typically and also at the appellate level.
And in the larger counties, like Wyandotte County, often even on the prosecutor's side, it's the same thing. They're often large district attorney offices have people that just handle appeals. And so we may not see the lawyer. In that case, it was Leavenworth County, not quite as big a county, and it's more likely you'll get the trial attorney. I was a trial court judge for about 11 and a half years, and when I come and listen to these arguments, I would prefer that it be the people that were at the trial, but we don't have that luxury.
If you would you tell the students what your educational backgrounds are? And I know, Judge Bruns, you had said when you started college that you knew you wanted to be a lawyer, which I'm pretty impressed about. But the education that it took to get where you're at, and maybe the road that you took to get there.
Okay, and we can all, this is your chance to work in Georgetown. He's a Georgetown graduate, so. But I'm a Kansas City, Kansas Community College graduate. So I graduated from Slagle High School in 1977. Do we have any stallions out there? There's a stallion. Yeah, okay. And the only way I could remember how to spell Slagle was by, in football, we had to do jumping jacks, and we had to spell out Slagle, so I learned how to spell it. In Topeka, they don't know how. When they announce the football scores or whatever for Slagle, they always misspell it. But I went there. I didn't know I wanted to be a lawyer, but I knew I had to study and learn to study. I knew that maybe I needed to save some money before I went on to KU, so I came here and got a degree in pre-law. And it was great because it gave you a real foundation for the types of courses that would do you well. A lot of speech classes, English composition classes, accounting, business law, and that's what I did. Then I went on to KU, and my dad asked me, one time I was back here, and I was a student at KU, and my dad asked me, what are you going to do if you don't get into law school? And I said, oh, I never thought about that. So instead of getting a political science degree at KU, which is where I was going, I transferred those hours over and got a degree in secondary education, but basically just used those hours from political science. But then I did my student teaching at Eisenhower Middle School here in Kansas City, Kansas, so if anybody went to Eisenhower. And then I went on, and law school is 3 years, and I went to Washburn University in Topeka. And I'm glad I did. Every school that I've went to has helped me immensely. But the main thing I think you need to do, especially here, is this gives you a great opportunity because you're here because you want to be here. You need to really learn how to study. Maybe you haven't learned that in the past. Maybe you have. And take advantage of the opportunity and get those GPAs up as high as you can so that when you move on, and hopefully everybody at least goes ahead and goes to, gets a bachelor's degree as well, and maybe a few of you will go to law school. So that's kind of my track. But why don't you tell us about yours real quick?
Well, I was going to say, Judge Knudsen has a fascinating life story, and so why don't we do his next?
What's the question?
Where have you been all your life?
Well, I was a bright and precocious child when I started kindergarten. Now we'll move it up. I grew up in Goodland, Kansas, in a rural community. I went to the University of Kansas for my undergraduate degree, a BS in business. You know, my track was really an interest in tax and accounting, and I pretty much determined I'd either get a master's in tax, perhaps at NYU or somewhere else, or I would go to law school and combine tax and accounting with my law degree. I went to law school at Washburn University, the same as David, and was very glad that I did. It gave me the opportunity to see other avenues that I could explore. I law clerked while I was there. I worked as a bookkeeper for a finance company, and I got married, and it gave me a little broader perspective as to opportunities. NOM was hot then, and we were getting drafted, so I took a job as an assistant city attorney in Wichita, waiting for the draft to nail me. And my wife became pregnant with our daughter Lisa, and At that time, I was then not required to report for service. And at that time, decided to start practicing law in Salina, Kansas, in a general practice. Grew into an insurance practice, pretty well did defense work for insurance companies. Eventually was appointed to the district court bench, served on the district court bench for 15 years, and then was appointed to the Kansas Court of Appeals, where I served for 8 years. And I took retirement in 2003, and these guys begged me to stay and help out on occasion, which I do.
Because he makes the rest of us look so good.
Did you go to school?
Thank you, Judge Bruns, I did. But it is interesting, you can kind of tell the different backgrounds, and that's one of the beauties of the legal profession, I think. I did my undergraduate work at Georgetown. I majored in political science and theology. I then went to KU Law School. Out of law school was 11 years at the Johnson County DA's office as a prosecutor, 3 years with the Union Pacific Railroad as a trial attorney, and 14 years with a private law firm, Shook, Hardy & Bacon, defending large international pharmaceutical companies. And then I was appointed by Governor Sebelius to this position in January of 2005. But what is interesting, I think, from all of these little life stories is, and the point should be made to you, one of the neat things about the law is everybody's got different interests, and the law will accommodate those interests. And so, for example, if you want to help poor people, you can join legal aid, and you can help poor people who really need help, legal services, especially in this day and age. You want to defend poor people who are charged with crimes, you can be a public defender on the trial level or at the appellate level. You want to prosecute people, be a prosecutor. If you think that adoptions are neat, or you want to get involved in family law is a good way to do it. You want to make tons of money, be a tax lawyer, and you can live the good life forever and ever, or intellectual property, patents, trademarks, things like that. Real estate, business, it just depends. Health law, if you have a bent towards the health profession. And especially for women, let me just say that when I graduated in 1977, there were a handful of women in my class. Today, there are more women entering law school